And for the record, the judge has abandoned court. This case is dismissed. I order this case be dismissed. Case number 25-1756-SM.
Before we even get into the courtroom chaos you're about to witness, let me set the stage, because this case is not just about an alleged assault, it's about a defendant who believes the legal system only applies when he agrees with it. Today we're looking at the return of Eric Martin, a familiar face who has once again landed himself behind bars after allegedly violating bond conditions and ending up right back where the court explicitly told him not to go. But what makes this appearance different, and frankly unforgettable, is that Eric doesn't just challenge jurisdiction like he's done before. This time he attempts something entirely new. He tries to dismiss his own case on the record, while claiming the judge has abandoned court. And yes, he says this with complete confidence. What follows is a masterclass in courtroom patience, legal reality checks, and the stark contrast between pseudo-legal fantasy and actual law. Stick around because this hearing spirals quickly, from constitutional buzzwords to bond denial, to one of the most confident misunderstandings of how courts work that you'll see all week.
Okay, now we're on Eric Martin. This is 251756, the People versus Eric Martin.
Good morning, Your Honor. James Gazicki on behalf of Mr. Martin. Your Honor, he's waiving his right to a trial by jury, requesting trial by this court. And also, can I address bond, Your Honor?
Yeah, I signed the order granting discovery. Mr. Martin, you understand that you have a constitutional right to a trial by jury?
I comprehend that.
Do you understand that, sir?
I comprehend it. I just want to add, as I told him, I really don't consent to no jurisdiction of this court, but since I'm being forced to make the choice, I'm saying an Article 3 judge is going to be the choice, the forced choice. Article 3 judge.
Okay.
Even though the case shouldn't go, let me mention this too now. The case shouldn't go that far. We shouldn't even be wasting taxpayers' money, nor my time in here. First of all, I proved my sister lying before on me with the same type of charge, Nessick, okay? I don't know the case number right now. I asked Jasinski to find out what it is. But in the same court, 23rd District Court, the judge is seeing she lied when I questioned her, did you swing at me before I kicked you? She answered no to that, and it was seen on the camera she lied. This is especially why I should not be made to wait on this.
Mr. Martin, you have a constitutional right to a trial by jury. Are you voluntarily waiving the right to a trial by jury?
Since I'm being forced to make
well, you're not being forced to make any choices.
Well,
you can have a trial
by jury. So I am being forced.
Mr. Martin, listen, we can get through this, or we can go back and forth, and then I end up muting you, and then that's how we go forward. So let's see if we can do this without that, okay? You have a constitutional right to a trial by jury on this case. Are you waiving your right to a jury trial?
Yes.
This is where we immediately see the familiar pattern re-emerge. Eric claims he comprehends his right to a jury trial, but comprehension and acceptance are two very different things. Notice how he frames everything as coercion. He insists he's being forced to choose, while simultaneously trying to introduce an Article 3 judge argument that simply doesn't apply here. This is a common tactic in sovereign-style defenses. Redefine the rules mid-conversation and hope the court plays along. But the judge stays laser-focused, repeating one simple question: jury trial or bench trial? Because legally that's all that matters at this stage. Eric, meanwhile, wants to litigate jurisdiction, past cases, alleged lies, and taxpayer money before a trial even begins. This is important for viewers to understand. Pretrial hearings are not the place to argue guilt or innocence. They're about procedure. And every time Eric refuses to give a direct answer, he's not outsmarting the court. He's delaying the inevitable while digging himself deeper into a procedural hole.
And you understand that I'm the judge of the court, that I will be the trier of fact on your case?
Well, I want a motion for the judge trial, but I'm gonna object to you being the judge based on past constitutional violations. I don't mean to
Okay, well, your
disqualify you,
motion for recusal is denied. So
Okay.
now, Mr. Mark, are you electing for me to try the case, yes or no?
In that force, the sense, yes.
Well, you have two choices, a jury trial or me. Out of those two choices, which one do you like?
Are you an Article 3 judge?
Mr. Martin, I'm not going to entertain jurisdictional arguments. I'm asking you, do you want a trial by a judge or a jury? And I'm being very patient.
By a judge, I already said, Article 3 judge. Article 3
Okay.
judge.
Okay, well, I will be your judge. I've made that clear. This is a case I have jurisdiction over. It's a misdemeanor that's alleged to have occurred in the city of Taylor. So you're indicating to me that you're relinquishing your rights to a trial by a jury, and you'll be tried by me. And you understand, you've had a chance to talk to your lawyer about this, Mr. Martin?
Yep.
Okay.
I also want to make it clear, I have some other things to say. I enforce my right to a Republican form of government under Article 4, Section 4 of the U.S. Constitution, which is why the court don't have jurisdiction over me. And I am the third party beneficiary here. I am not the defendant.
Can you find
Despite the fraudulent presumption otherwise.
Possible.
Here's the irony Eric doesn't seem to grasp. If your entire defense rests on unconventional legal theories, a jury trial is usually your best shot. Judges have heard these arguments countless times, and they know exactly where they lead. Yet Eric insists on a bench trial while simultaneously objecting to the very judge who would preside over it. You can hear the contradiction unfolding in real time. He wants a judge trial but not this judge. He claims constitutional violations without identifying any legally recognized ones. And when the court denies recusal, Eric treats it as further proof of wrongdoing rather than what it actually is, a routine decision grounded in law. The judge's patience here is key. She narrows the conversation back to two choices, explains jurisdiction clearly, and gives Eric multiple chances to make an informed decision. This isn't oppression. This is due process being offered repeatedly, even when the defendant refuses to engage with it honestly.
All right, give us a second, Mr. Martin. I'm trying to get your jury trial date. We can even do on a state day.
I want to make clear, I'll point out, it's supposed to be 28 days, and Saturdays and Sundays are not supposed to be excluded because the 28 days is specific for speedy trials and misdemeanors. And since that's specific, under the court rules, it should be 28 days without excluding Saturdays and Sundays or the legal holidays. That's made clear, I want to say, under the rule that dictates speedy trial, MCR 6.004C, and also MCR 1.103, the applicability rules that clearly says, where a rule is specific, it applies to that. So that the specific rules control over general rules.
Okay, Madam Prosecutor, how many witnesses?
I would say maximum 3.
Okay, Mr. Gazicki, how many witnesses?
Your Honor, first of all, I just want to put on the record that Mr. Martin in the past has not wanted my representation of him. Today, he says it's okay for me to represent him. I just wanted that on the record. I also advise Mr. Martin that his arguments that he makes about sovereign citizens and that is something that I can't follow, nor can I ask the court to follow it. Just so that's on the record. As far as witnesses goes right now, Your Honor, would say 1.
Okay.
Can we approach?
I mean, Mr. Gazicki's in the other room. Mr. Gazicki, can you come on in? We'll meet you in the back hallway. All right, Mr. Martin, 1 second.
Yeah, and I got something to say too, we get time in response to what he said.
This segment perfectly illustrates why defense attorneys distance themselves from sovereign-style arguments. Eric invokes a Republican form of government, claims third-party beneficiary status, and denies being the defendant, all while standing in court under his legal name. His own attorney makes it clear on the record. These arguments are not something he can ethically advance. That moment matters. When your lawyer tells the court he can't follow your legal theory, it's a red flag, not about bias but about viability. Courts operate on statutes, rules, and precedent, not wordplay. Eric's attempt to redefine his legal identity doesn't negate jurisdiction. It reinforces why the court must stay grounded in established law. And while Eric continues citing court rules selectively, the judge keeps the proceedings moving, focusing on witnesses, scheduling, and trial logistics. The real mechanics of justice, not theoretical loopholes.
And for the record, the judge has abandoned court. This case is dismissed. I order this case be dismissed. Case number 25-1756-SM.
This is the moment that feels surreal. With the judge temporarily off the bench, Eric declares his own case dismissed, announcing it as though authority flows from volume and confidence rather than the court. This is a classic example of magical thinking in legal form, the belief that saying the right words transforms reality. But dismissal isn't a declaration. It's an order issued by the court, under specific legal standards. The fact that Eric genuinely believes this work tells us everything about the mindset at play. It's not strategy, it's performance. And while it might sound humorous on the surface, it also explains why these cases rarely resolve cleanly. When a defendant refuses to recognize the legitimacy of the process, every step forward becomes a struggle. The law, however, doesn't bend to belief. The case continues unaffected by the announcement.
All right, we're going to set a bench trial July 14th in person at the 23rd District Court, July 14th at 10 a.m.
Your Honor, can we address bond?
You can address bond.
Okay, Mr. Martin requested that I ask this court if he can have a no condition type bond in this matter.
Okay, here's the problem. I'm just going to say it on the record. Request for a bond modification is denied. Mr. Martin had a very simple bond condition that he not go back to the residence. I know he doesn't think I can tell him that, but he's wrong. And he went back to the residence and got arrested again, allegedly, for being at the home when there was a no contact provision in place. So he clearly has a history of non-compliance. He doesn't think the court has jurisdiction over him. And the only way I can assure his presence and assure the safety of the community is to keep Mr. Martin in custody because he will not comply with my bond conditions. There's no such thing as an unconditional bond. So, okay, bond denied. And Mr. Martin, if you want to file motions that Mr. Gazicki legally could not file in good faith, feel free to file them. He's governed by court rules. He cannot file frivolous motions. So if you want to file more motions, feel free, get it, go at it. But Mr. Gazicki has indicated for the record, he will only be filing appropriate motions with this court. We'll see everyone back on the jury trial. That's my first date.
I have motions to make right now. I have some motions before we leave. I have some motions. Okay, and that is okay. Well, first, objection to what you just said, your statement about there's no such thing as an unconditional bond. Yes, it's my right to be presumed innocent under the due process. The due process right, be presumed innocent before guilty. Because I am presumed innocent, that is why any bond conditions violate that right.
Here's where consequences finally take center stage. The judge lays it out plainly. Eric had one simple bond condition: stay away from the residence, and he violated it. That's not theoretical. That's documented behavior. Bond isn't a reward. It's a conditional privilege designed to ensure compliance and public safety. Eric's repeated refusal to follow court orders, paired with his insistence that the court lacks authority over him, makes release untenable. The judge's reasoning is textbook. Non-compliance equals increased restrictions. And when Eric argues that any bond condition violates the presumption of innocence, the court corrects him immediately. Presumed innocent doesn't mean unrestricted. It means the state still has to prove its case, something entirely separate from ensuring someone shows up to court and doesn't reoffend. This is law functioning exactly as intended.
So
okay, motion denied. What's your next one?
Okay, and I motion to dismiss because there is no probable cause. It is her word against mine. She's lying. She's been caught lying before, and there is no evidence at all. We have no case. There's no evidence, and that is not probable cause, as the U.S. Supreme Court said in Beck versus
Well,
Ohio.
it's a misdemeanor, so we're not having a preliminary exam, we're having a bench trial. And the prosecutor will have to prove the allegations beyond a reasonable doubt. And at
Right.
that time, Mr. Martin, if at trial date, I assure you this, if she can, you picked a bench trial. I was a practicing attorney for years. I promise you this, if she cannot prove her case beyond a reasonable doubt, the case will be dismissed.
Okay, but anyways, let me finish talking. I didn't finish talking about the motion to dismiss.
I know, but Mr. Martin,
as of right now,
what's your last motion? Do you have one more?
you haven't let me finish the
I-
you haven't let me finish the motion just based on no probable cause.
Okay,
As the U.S.
denied.
Supreme Court said in Beck versus Ohio, or it was Ohio versus Beck, I forget which word is first, but the probable cause is defined as fact sufficient for the belief. Her word against mine. I told the cop she lied on me. Okay, her word against, we simply have her word against mine. That's all there is. So that's
Okay,
not fact
well,
sufficient for the
and
belief.
Mr. Martin,
There's no
I'm
probable
going by the
cause
jury
now. The
instructions.
case should be, come on, let me
Okay,
finish.
denied. All
The
right,
case
Mr.
should be
Martin, we're
dismissed
wrong.
now.
We'll see.